Welcome to K&L Gates Working Wise podcast series. My name is Laura Scully, and I'm an associate in the firm's labor, employment, and workplace safety practice area. In this podcast, I will discuss key legislation that the New York State Governor signed on August 12, 2019, as part of his 2019 Women's Justice Agenda. Effective immediately, employers are now required to provide in English, as well as the language an employee identifies as his or her primary language, at the time of hiring and at every annual sexual harassment prevention training, a notice containing the employer's sexual harassment prevention policy and information presented at such training. Effective October 11, 2019, harassment because of a protected characteristic will be unlawful regardless of whether such harassment would be considered severe or pervasive under precedent applied to harassment claims. The new legislation clarifies that harassment is illegal when it subjects an individual to inferior terms, conditions, or privileges of employment because of one or more of the individual's protected characteristics. Employers will have an affirmative defense to harassment liability when the offensive conduct does not rise above the level of what a reasonable victim of discrimination with the same protected characteristic or characteristics would consider petty slights or trivial inconveniences. Additionally, the legislation eliminates a potential defense available to employers based on an employee not complaining of harassment to his or her employer, providing that such failure on the employee's part shall not be determinative of whether an employer shall be liable. Additionally, and also effective October 11, 2019, the legislation makes employers liable for unlawful discrimination against non-employees in the workplace when they knew or should have known that the non-employees were subjected to the unlawful discriminatory practice in the workplace, and they failed to take immediate and appropriate corrective action. Non-employees include contractors, subcontractors, vendors, consultants, and other persons offering services under a contract in the workplace or those who are employees of such persons. Come October 11, 2019, agreements settling claims, the factual basis for which involves discrimination, cannot prohibit disclosure of the facts and circumstances underlying the claims, unless confidentiality is the complainant's preference. The condition limiting the disclosure must be in writing in plain English, and if applicable, the primary language of the complainant. The complainant must be given 21 days to consider the non-disclosure condition. If after the 21 days the condition is the complainant's preference, the preference needs to be memorialized in an agreement signed by all parties. Thereafter, the complainant must have at least 7 days to revoke the agreement, and the agreement may not become effective until the 7 days have passed. The condition circumscribing disclosure may not restrict the complainant from initiating, testifying, assisting, complying with a subpoena from, or participating in any manner with an investigation conducted by a government agency, or filing or disclosing any facts necessary to receive public benefits to which the complainant is entitled. Moreover, effective October 11, 2019, any contract or other agreement between an employer and an employee or potential employee entered into on or after January 1, 2020, that prevents the disclosure of factual information related to any future claim of discrimination is void and unenforceable, unless the provision notifies the employee or potential employee that it doesn't prohibit him or her from speaking with law enforcement, the EEOC, the New York State Division of Human Rights, a local commission on human rights, or an attorney retained by the employee or potential employee. Contracts also cannot contain clauses requiring arbitration to resolve discrimination claims as a condition of enforcement of the contract or obtaining remedies under the contract. This restriction, though, may be limited to the extent the Federal Arbitration Act is considered to preempt it. Effective February 8, 2020, The New York State human rights law will apply to all employers within the state, not just those who employ 4 or more persons. A prior amendment only resulted in all employers being subject to the law with respect to sexual harassment claims. Finally, effective August 12, 2020, the statute of limitations for sexual harassment claims will extend from 1 to 3 years. We hope that you enjoyed this episode of K&L Gates' Working Wise podcast series. More episodes in our series can be found at klgateshub.com. You can learn more about our labor, employment, and workplace safety practice on our main website, klgates.com. Thank you for joining us.